SJC-13490, William Good v. Uber Technologies, Inc., and others.
Okay, Attorney Huston is first.
Good morning, may it please the court. I'm Michael Houston of Perkins Coie on behalf of the Uber defendants. I'll address all of the contract formation issues in the case. Mr. Monson will be available to address any questions the court may have about the claims against the independent driver defendant. The Superior Court's decision refusing to enforce the parties' agreement in this case should be reversed because it's contrary to this court's precedents and contrary to the overwhelming weight of authority in other states. It is notable that plaintiff asks this court to make this Commonwealth an extreme outlier. Plaintiff's brief does not cite a single decision by any appellate court anywhere in the country.
We don't really have to go too far to figure out what the relevant law here is, right? It's Cowder as an Archer, right? So why don't we, before we get into a speech, why don't we focus on those, okay?
Certainly, Your Honor. I think that Cowders and Archer, as Your Honor points out, make clear the standard of contract formation, and that standard clearly dictates that this contract is enforceable. The key point in the court's holding in Cowders was that a clear and simple interface conveys to a reasonable consumer that they are the terms that are going to bind him. And this type of I agree checkbox is exactly—
It's not an I agree checkbox. It's a confirm checkbox. And hold on, I know it says I agree and confirm, but it's not just I agree to one thing. It's I agree includes privacy, includes the age. But you know, going back to Justice Kafka's initial point, the histrionics, the trickery on one side, the sky's falling down on the other side, not helpful. We're trying to really dig in here and get this very important issue right. And it's the totality of the circumstances on reasonable notice. And this is not a registration situation. This is an update. Someone's trying to get a ride. They've got a message that says update, and they want their ride, and they can manage to get through all of that without ever seeing the terms and conditions and find out that this is actually an initial contract, not when they're registering, but when they're trying to get a ride.
So, Justice Lowy, I think the most important thing in the question that you just asked is that is the suggestion that a person could get through all of this without ever being aware that they were agreeing to terms of use. I just don't think that page 66 in the record, which is the interface, makes that possible. That was the key holding in Cowders. The court thought that a person could click and get all the way through the process without being aware that there were terms to which they were going to be bound. But here, the whole point of the screen is to call the user's attention to the fact that Uber has updated the terms on which we are offering the use of our services. That's what terms of use are. And then there's exactly the kind of language.
Terms of use, interesting choice of words, right? You know, terms of use, we're updating our app, terms of use, not any language typical of you're entering into a contract, agree, right? Whether it's enough or not, I don't know, but it's not clear in the sense that you're arguing. It doesn't say update, you know, after Cowders, basically, we have no contract with you. Please, you know, read these terms of this agreement and agree to them. It's much more opaque than that, right?
Justice Kafka, respectfully, no, I'd strongly disagree with that. The biggest text on this page is, we encourage you to read our updated terms in full.
Encourage.
We are urging Mr. Good to read these terms. We want him to do so. We're not trying to hide them.
But you just flipped verbs. You went from encourage to urge. And I think if you had that pop-up page that says words that are far more prescriptive than just, hey, it's almost aspirational. Hey, we encourage you to read it. More stronger terms that says you have to read this, or we urge you to read this, or read. Just read the terms. But when you say encourage, that seems to be almost, hey, you can or you can't.
Well, I think, Your Honor, we can never force we cannot physically compel someone to read the terms. I think saying we encourage you to read our terms goes beyond what's required. I mean,
No, well, you do it with your drivers, right?
Right.
Your drivers, you're not going to be an Uber driver unless you read these terms and agree to them.
So,
The drivers know they're entering into a contract.
so respectfully, Your Honor, I think that
Well,
I
go
appreciate
ahead.
the opportunity.
Let me just finish, lay out the question, then I won't cut you off. The drivers, we know that Uber knows how to clearly state in an internet contract that you're entering into a contract and agree to it. What do we do with that when you don't do that with customers and use much more open-ended, vaguer terminology?
So I have to respectfully take issue with the premise of the question, because I think that what the court's opinion in Cotter shows and what the actual reality is that the interface that drivers use to sign up it's not identical, but it's very, very similar, and it has all the same.
Well, please, I wrote Cowder's. It's not the same. It may be good enough for government work, but it's not the same.
It's similar in this key respect. Both involve a hyperlink. Neither one involves what the plaintiff says is required here, which is actually forcing somebody to read and review the terms. They both present the terms by hyperlink.
I agree with you. We did not say that you need to have a scroll, whatever that terminology is, scroll agreement, where you have to scroll through the terms. But we were clear that we wanted you to, put in language that put you on notice that you were entering into a contract that's significant. Not only are you agreeing to ride in the car, and you're giving up your right to sue Uber, you're giving up your right, basically, if you get killed or raped, Uber's off the hook, right?
No, Your Honor, that's respectfully, that's not correct in a couple of respects. First of all, I think any question about the terms themselves is expressly delegated to the arbitrator. That's not what we're talking about here today. We're talking about the standards of contract formation, which, as this court explained, are supposed to be the same for online contracts as for all other kinds of contracts.
I agree with that part, but does your contract doesn't take Uber off the hook? If the driver rapes you or the driver drives into a wall and kills you, doesn't this contract say Uber is off the hook?
No, Your Honor. The first thing to say about that is that if the claim involves sexual assault, which of course this claim does not, they're excluded from the terms. It's not what this case is about. Even in a case, I think this we're talking about
the latter.
We're talking.
You get killed. Can you sue Uber under the?
Mr. Good is going to have the opportunity to take his claims, his alleged negligence claims, to an arbitrator. So, and that's the proper forum. It's a forum that the public policy of this state and the Federal Arbitration Act supports as a means of expeditiously and efficiently resolving disputes. The question in the case is, did a reasonable person reading this screen at RA 66, would that person have known that they were entering an agreement, and would they have known of where those terms were located if they wanted to review them?
And here's the challenge. It may well be that it's enough here. It may well be that it's clearly enough when you're registering with Uber. But the issue that you just hit on is the interface enough in the context of this case? In the context of this case, when you're not registering and you're trying to get a ride, is the update and the confirm enough to give reasonable notice?
Well, respectfully, Justice Lowy, it's not just the update and the confirm. I think the court needs to look at the entire interface together. The key language in the interface is the presentation of the terms of use hyperlink, not an obscure, not an odd little box, a classic blue underlined hyperlink. Everybody who lives in the digital world knows what a hyperlink is and how it works and how to click on it to get access to the terms. It says we have updated the terms on which we are offering the use use of our services. And it says, by checking this box, I have reviewed and agree to the terms of use. That is the sort of solemn language that this court in Cotter said puts a regular user on notice that they are entering an agreement. The phrase, I agree, conveys, I am entering an agreement. And then, just for good measure, we have added the confirm button, which is just to make sure that somebody doesn't inadvertently click the thing. This way, you have to take 2 separate steps.
I know, but again, it may be enough in this context. It seems clearly enough if it were initial registration. But it doesn't say what you say it says. It doesn't say, I agree to the terms and conditions. It requires an acknowledgement of the privacy and the age is 18. It's just not that clean. It well may be enough, but I really don't see this case as a big, huge case. I see this case in the context after Cotter's, whether the pop-up message when you're trying to get a ride, when you're already registered, is enough to give you reasonable notice here that you're entering into a contract with huge implications.
So I'd like to address your point that this is an update situation. Companies...
That's not my point. Doesn't it say that?
Sure, this is an update. No.
It's not my point. We encourage you to read update.
Yes.
It's your words. It's not my term.
I just want to address Your Honor's question about the legal significance of that. The point, I think, is that companies change the terms on which they offer the use of their services all the time. That's a good and healthy thing in the economy. Companies need to be able, having made a contract at one time, to say, we're moving away from that.
You didn't make a contract. We said you hadn't had one before.
I understand that, Your Honor, but
So you were starting from scratch. Now, you may not have thought you were starting, you may not want the user to know you're starting from scratch, but you had no binding agreement with Mr. Good before this, correct?
as a matter of law, because of Cotter's, that's true. But I think, if anything, that only means that we're in the situation that I think Justice Lowy referred to a minute ago, where this is this is the registration, this is the new contract. And I think that's the key point.
By the way, that'd be nice if that were what it said. We have a new contract. Agree to the terms, or you're not going to ride our cars. That's not what it said.
And sorry
Could
to
I just get
interrupt,
that answer, then I'll defer to you.
Your Honor, we do business all across the United States. Uber needs to have a uniform way of conveying to its customers all across the country that it has changed the terms on which it is offering the use of its services moving forward. That's the point of this. We have updated our terms for using our service. We sent that. It wasn't like this was created specifically to address Cotter's and this Commonwealth. This is a national rollout of a new contractual arrangement for all of our customers. We need a way to do that that is coherent and uniform. That's why you see language that ordinary, regular people understand. We've updated the terms on which we're using
Ordinary, regular people do this all the time. Apple, it says, you're entering into a contract, agree, right? I mean, you can do that. The question is why you're not doing it more clearly. This may be clear enough, again, I'm not saying you're not, but it's not perfectly clear. And people are reluctant to read these long things. Right?
So I want to make two important points about that, Your Honor. The first is that the evidence strongly shows, and the evidence that this court relied in Cotter shows, that people don't read contractual terms no matter what you do. Even if you have a scroll wrap that everybody agrees is basically per se enforceable, they don't read it. Even if you make people initial every paragraph in mortgage documents, people don't read it. So I don't think that the legal rule here can be based on a fiction about what...
When you're entering into a mortgage, you know that's a contract. When you enter into a car lease, you know you got a car lease. When you enter into a Uber car, not so clear exactly what you're agreeing to, right?
And that's the function, as this court explained, of the language on this interface that says, I have reviewed and agree to the terms of use. The point of that language is to call the user's attention to the fact that they are entering an agreement. I agree to the terms of use means I acknowledge that I'm entering an agreement. And as I think Judge O'Toole from the Federal District Court in the Daily Fantasy Sports case pointed out, the question is not whether the interface could have been better or more clear in some respect. The question is only whether it is reasonable notice. It is not a conspicuous standard, as the court made clear in Cotter's, just reasonable notice. Thank you.
Okay, thank you.
Can I
very-
ask one
oh,
last
sure,
question?
I'm sorry.
Thank you. This screen has been on RA 66 has been referred to as a pop-up screen. I just wanted to ask a factual question. Could Mr. Good book a car without checking the box and clicking confirm?
No, Your Honor, as the record, I'm sorry.
So it was actually a blocking screen.
Yes.
You couldn't go forward without doing both of these things.
That is correct. A user would have been confronted with this at the moment that they were attempting to access Uber services, which I think is the time when you are most likely to cause somebody to focus on the term, as the Second Circuit explained in Meyer. It was necessary for a person, in order to access Uber services, both to click on the box attesting that by checking this box, I have reviewed and agreed to the terms of use and acknowledged the privacy notice, and then to take the further step of hitting confirm. That's very similar to the process that drivers use, as the court explained in Cotters. There, too, it's a hyperlink that says, please acknowledge that you have reviewed and agree, but the person is not actually required to click on the hyperlink.
Can I follow,
And
Chief?
I have one after Justice George.
You're interested, huh? Go on.
Just with that last point, Chief, you say that, but you almost make it seem like it's a casual context when that arises. You want to ride home. Mr. Good wanted to go home. He'd worked all day, and he wanted to just go home. You make it seem as if that's the most opportune moment to seize upon someone who wants to go home, that now is the time for you to sit back and look at all of these terms and conditions. Isn't that the worst time for you to sit back and look at these terms and conditions when you just want to go to wherever you're going?
No, Your Honor, I don't think so. As the second,
When would be?
well, I think no. When would be the worst time?
No, when would be a worse time than when you're leaving a bar, you're leaving work, you're late at night, you're tired, and you just want to go home?
So I think two points about it, Your Honor. The first is that it's not the case that Mr. Good just agreed to these things on his way home and then never had an opportunity to revisit it. The accident that occurred in this case was several days later. He could have, at any time, even if he was in a rush to get home and he was tired and he sort of didn't know what he was doing, the terms of use remain visible in the app at all times. He could have pulled them up at any time and reviewed them in the comfort of his own home, and then made a decision. You know what, actually, I'm uncomfortable with those terms. I don't want to agree to them, so I'm not going to use Uber services. And he could have done that. So I think it's just not the case that he was sort of rushed into a decision and then, minutes later ended up in this auto accident. That's not the factual reality. But I think the more important legal point is that the company has to make a decision. We've changed the terms on which we're offering our service. How should we go about providing that notice? The Superior Court said, well, you should send an email or give a person a phone call. But I think ordinary people are much less likely to pay attention to an email that just pops up out of the blue one day from Uber saying, we've changed our terms, than if at the moment that I'm interested in actually using Uber's service, Uber informs me we're changing the terms. I think the latter, you tell a person about the terms of the bargain at the moment that they are interested in accessing the service that is the subject of the bargain. That's how companies do business, and I think it would be quite dramatic if this court was to say that's actually not an acceptable means of providing that notice.
Can I ask one question on actual notice? So I'm going to ask your opposing counsel about actual notice. So what do we know about actual notice here? He checked the box. By checking the box, I have reviewed and agreed to the terms of use. You keep track of whether he checked the box, but I take it your app could also indicate whether you actually looked whether he checked. You don't make that point. You don't say that you've confirmed that he read them, right?
So the record doesn't reflect whether...
Is that because you don't track that function?
I believe that is correct, Your Honor. In truth, I don't know, and the record doesn't reflect it, but that's my understanding, that we do not keep records of who clicks on a hyperlink specifically. We keep records of who clicks...
What do we do with that fact? Because that's...
Yeah, sure.
Because I'm going to ask him, okay, you clicked the button that said you read this.
Right.
You don't remember what you did.
Right.
They know you clicked the button, but they didn't check whether you actually looked, even though they could. So I'm just trying to figure out where that leaves
I
us.
appreciate the opportunity to address it, Your Honor. Actual notice turns on an issue of fact. Did or did not Mr. Good review these terms before agreeing them? That's a factual question. We asserted in the trial court at RA 53 that Mr. Good did, in fact, read these terms. And we backed up that assertion with record evidence, namely his own submission through this ClickWrap interface that he had reviewed the terms and agreed to them. I think that met
he
our...
says that although I don't remember what I did, my habit is, in order to use these apps, I click but don't look,
He said-
which, by the way, 99.9% of Americans are probably doing out there. But again, we don't have record on that. I'm trying to figure out what we do with the actual notice, because that's dispositive of this case.
It is.
If we have the information, we need to decide.
That's right. I think the first appellate department in New York addressed this in the Wu case. I would urge the court to take a look. It's exactly the same situation. The court's holding there is that on this question of fact, we met our prima facie burden on a summary judgment standard to put the factual issue in the record with our assertion at RA 53 backed up by the evidence in the form of his own submission. That met our prima facie burden. Then he has the obligation to come forward and contest that. And many people do this all the time. They say, you know what, I checked that box, but in fact, I didn't read it. If he had done that, it would have been a disputed issue of fact. It would have precluded summary judgment on that ground. But Mr. Good didn't do that. All he said was, I don't remember checking this box. And then, as Your Honor points out, he said, it was my practice when I got advertisements, pop-up advertisements online to quickly get rid of them. I understand that. I do that too. But this is the kind of solemn, I agree language that the court in Cotter said exists to put users on notice that they're entering a contract. This is not just like a promotional advertisement. So I think the fact that somebody's habit was to click away quickly from advertising does not suggest that they were likely to take the same approach with regard to solemn I agree language. And all we're saying is Mr. Good has the obligation to contest
It's not solemn,
it.
I agree language. But anyway, okay, I get your answer. Thank you.
Thank you.
Okay, thank you. Attorney Monson?
The appellants are in line with the different arguments that Mr. Houston rang, and I'm not going to read out, and I'm not going to repeat all of them. I did want to answer one of the questions that I thought was directly on point on the issue of the terms matter. And in this agreement, it's not just I agree to the terms. It's by clicking on the box, which is right next to this language, I have reviewed and agreed to the terms. It's both telling you that when you click this box right next to this terms,
And
that
keep
you're
reading and acknowledge the privacy notice. I am at least 18 years of age, right? It's a little vaguer. It doesn't just say, I agree to the terms of a contract, click. It's different. It's again, more opaque.
I agree that there is additional language after that, but I would offer to the court that there's no way to read that next to a box that you've checked and conclude that you're not agreeing to those terms that are included in the hyperlink.
By the way, just on the contractual point, so Uber's not off the hook? They haven't put the whole burden on your client? When I go through this contract language, it's going to allow an arbitrator to find Uber liable in addition to your client for what your clients.
I don't have an opinion on that, Your Honor. I will say that
What's the record say? Have you read that?
I've read through the agreement, Your Honor.
What is it?
There are-
Uber's not off the hook? I just want to I'd like your take on that, given that I thought they shifted the whole burden to your client.
I don't see it as being shifted, the entire burden to my client on the language itself. There is limitations of liability language in there.
And what is the limitation of liability for Uber as opposed to your client?
I'm sorry, I don't know if I understand the question.
Did Uber leave you alone holding the bag in this contract you want us to enforce?
There are some instances where Uber will be protected from liability.
How about for a car accident that results in someone being a paraplegic?
I'm not sure, depending on the facts of the case and how they play out. There's certainly different ways around that liability language. I'm here just representing Mr. Yohu on his.
I assume you have you want us to enforce this contract. I just want to make sure I have your take on what Uber is left. Is Uber potentially liable in the arbitration, or is only your client potentially liable in this arbitration under the contract you want us to enforce?
I think there are still ways that Uber could potentially be liable. There are different sets of facts that,
For this car accident?
yes, Your Honor.
Okay, we'll read through that.
Thank you, Your Honor. I did also want to discuss, I know I'm past my time.
Just want you to be careful what you wish for.
Understood, Your Honor. We acknowledge the benefits that arbitration provides, and that's what we're getting at here. That's what we're interested in here. We will fight the good fight and defend our client on the facts once we get to arbitration. I know I'm past my time.
Yeah, you got 30 seconds, go on.
All right. I would just like to say, as far as the arbitration agreement applying to my client as well, the language is pretty clear. It applies to any third party where the accident's involving the use of the Uber services. I don't think even the appellant is challenging that if this is an enforceable agreement, that it would also cover my client as well.
Okay,
Thank you.
thank you. And Attorney Wessler.
Thank you, Your Honors. May it please the Court. Matthew Wessler on behalf of the appellee, William Good. I just want to, just a factual answer to your question, Justice Kafker. On RA 80, you will see this is part of Uber's contract. There is a
Speak
sweep.
a little louder, sorry.
On RA 80 of the appendix, you'll see that there's a sweeping indemnity clause in Uber's contract that, that by its terms attempts to hold Uber not liable for any conduct arising out of the use of the service.
And that was my recollection as well.
Yes, correct. So I would like to start with reasonable notice. I understand you also have a
Can
question.
you actually start with actual
I will
notice?
flip it and start with actual notice.
Yeah, because that seems to me an issue on summary judgment. Uber has come forward with evidence that your client actually did confirm having read and agreed to the terms of use, and your client came back with, I don't remember.
Sure. So, so let me start by saying that in the briefing below, Uber never actually made an argument that Mr. Good actually read the contract. Now, it points to this one sentence in its brief where it just quotes the language that it included on this pop-up. But to establish that a person actually read the contract, what this court has said in Archer and in Cowders is that there needs to be some evidence that the person actually went to the page with the contract or at a minimum interacted with the link in some way. But that isn't what Uber put in front of the court as part of its evidentiary burden. Instead, all it did was point to this checkbox language.
What cases, because that's important.
Yeah.
So we have said, again, we're at summary judgment stage,
Yep.
right? So there are cases that say you need to, again, because you won on summary judgment, so I'm trying to get a sense of what's going to support your position with these disputed facts, which is you clicked on I reviewed the terms, your client doesn't remember what he did, although he describes his past practice. Uber, which has the obvious ability to track whether he looked at the terms,
Correct.
hasn't done that, and we're kind of, and I mean, is that an issue that has to be tried? Because, you know, somebody could dig into whether this actually did happen. Maybe, I don't know.
Yeah, so I don't think the issue has to be tried because, number one, first and foremost, it's Uber's burden here to come forward with evidence actually demonstrating that the plaintiff went to the contract. Whether the plaintiff says, I don't remember.
Here's their proof. I mean, this issue didn't get a lot of attention. We've got the recent Wu case from New York that was briefed late in the appellate litigation here. But here is the evidence that Uber has, that there's actual notice. It's not complicated. What they have is that your client confirmed that he reviewed and agreed to the terms. That's the evidence. So where's the genuine issue of material fact on actual notice?
Well, so I don't think that's, I would push back on the premise, Justice Lowy, that that is evidence of Mr. Good actually reading
That
the
he did.
terms.
I have reviewed and agreed to the terms of use, and he hits confirm.
So-
I'm not saying that evidence, if the case had to be tried because it was contested, would satisfy a burden of persuasion.
Right.
Where it's summary judgment, or the analogy to summary judgment here, and we've got uncontroverted evidence that he said, when he hit the confirm button, I have reviewed and agreed to the terms. Where's the genuine issue material fact on actual knowledge?
Well, to the extent that there is a genuine, or to the extent that you're asking, where's the contrary record evidence, it's from Mr. Good's affidavit where he said, I don't remember reading the terms, and I, as a practice, wouldn't read the terms and just click the
I'm going to put
box.
aside, by the way, that the evidence law in Massachusetts doesn't allow habit evidence in personal circumstances, and it would actually be a really interesting question whether that would even be admissible under our current common law of evidence. I'm just going to put that completely
Okay.
aside for the moment.
Okay.
It's a big issue, though.
Okay.
All right, but that doesn't tell you what he did here. What we have, the uncontroverted evidence of what he did here, is that he has agreed that he reviewed the terms of use.
So a couple of things. I mean, that language or something similar to it was also present in this court's decision in Archer and in this court's decision in Cowders. All of these pop-up windows or interfaces have some kind of language that's similar. And if that were enough,
But I thought, again, I may be misremembering, in Cowders, we didn't have anything that explicit, right? We have this confirm at the end, done, we have done at the end. It's not, this is more explicit, much more so.
maybe for Cowders, but I don't think for Archer. And if you go and you look at Archer, there was very similar language there. And what the court said there, in actual knowledge, whether the plaintiff actually read the contract was at issue in that case. And what the court said was that's not an actually read inquiry. That goes to whether there was meaningful assent under reasonable notice. I think what you will find if you sort of canvass the cases on actually read is that to meet their burden, defendants or companies have to come forward with evidence like a log demonstrating that the plaintiff visited the website, or at a minimum, as this court said in Cowders, interacted with the link in some way. The companies track all of this information and have the ability to come forward and show this person visited this website or this page at this point in time on this day and this time. And to free a company from that obligation and instead to allow it to rely on just the click of a checkbox, I think would drastically lower the standard of the burden for demonstrating actually read. If I
Ask you now to pivot where you wanted to start, because I'm really curious as to why a block screen, a clipboard with a pencil with an X next to it, a statement that we encourage you to read our updated terms in full, 2 blue clearly hyperlinks, 1 being the terms of use, the empty checkbox with the I agree and I reviewed language next to it, the smaller font that I'm at least 18, you have to check the box in order to book the car, and then you must confirm. Why that is not enough in today's age for reasonable notice.
Sure. So I think there's a couple of responses to that, and I think I would start by saying, in Cowders, I think this court identified a basic framework for analyzing whether these interfaces are reasonable, in particular with Uber. And I think the starting point that this court said, you have to ask first and foremost is whether the transaction would be obviously contractual or not. So is there some reason why the person would, just as an inherent nature of the transaction, be looking out for contractual terms, extensive contractual terms? In the absence of that kind of transaction, where the transaction is not obviously contractual, I think what this court said was what's required at a minimum is that you put the terms of the contract in front of the user or in some way require the user to interact with the hyperlink. Uber didn't do either of those two things here.
But, I mean, here it's available for the user to interact with the terms of use.
Sure, but that was...
That in Archer was enough.
Well, so two responses to that. First, that was also true in Encounters. There was a link, and a user could, in theory, have clicked it, just like here.
But that's why I said the totality. That's why I read to
Of
you
course.
RA 66, because it's the totality of what was presented to the user at the moment that, in my opinion, he is most likely to be focused on what I'm agreeing to when I book a car.
Sure. So
Because in Encounters, it was done. I've registered, I'm done. Whereas here, it's I've reviewed and I've agreed to the terms, check that box, and then confirm it.
Right. So a couple of responses. I may just want to get back to your your statement about Archers, because I think Archers is actually a really useful way to illustrate why what happened here is ineffective. In Archer, what Grubhub did was the very thing that Uber didn't do here. It created an interface that actually identified as part of the link that what they were requiring workers there to agree to was a contract. It used the phrase arbitration agreement in the link. It wasn't terms of use. It also required the worker in that case to actually interact with the link. They were required to click the link. They couldn't proceed unless they actually clicked the link that said arbitration agreement. Now, there was a dispute in Archer. There's a footnote in Archer where the court identifies a dispute. Well, were you required to read the terms or not? That's a dispute. But at minimum, what's undisputed in Archer is that the workers in that case were actually required to click the link before they could register their assent. In this case, Uber did nothing like that. All it required the user to do was to check the box. It didn't require any interaction with the link. And I think Justice Wendland and Justice Georges, you both, and actually multiple of you on this court during my friend's opening, identified an additional problem that bears on this, on whether the notice was reasonable, which is that Uber pushed out this pop-up, and you identified this. It's not just a pop-up, it's a blocking pop-up at a point at which a user is at his or her most vulnerable. They are looking to get a ride. They are not primed and ready to think that what's going on is some kind of contractual assent.
Your client actually wasn't, unless he was getting a ride that day. It's 5 days later that he gets badly hurt, right? So do we know whether he was getting a ride the day?
He was getting a ride. In fact, the only time you would get this pop-up, Justice Kafka, is when you were logging on to the app to get a ride. And as a reasonable user, it's not so much what happened to Mr. Good in the particulars, but the question this court has to ask is, would a reasonable user, when they are looking to get a ride, either because they're trying to go home after work or they're running late to get to the airport, and they have to click this box to get through to get the ride.
When else are you going to focus on the transaction other than when you use the service?
Oh, well, so, we've identified other examples of companies where what happens is there's an email that is sent out in addition to a pop-up that says we are changing the terms of conditions. You can look at Lyft. What Lyft does is it sends out an email. It also, as part of its interface, delivers a pop. It's been doing this since 2016, that actually puts the terms in front of the user.
Can I ask you another question? Is it fatal, or is it required that the pop-up say the word contract or agreement? Is update sufficient?
So I don't think there's any one factor that is fatal or not. I think it's a totality of the circumstances inquiry. But if you look at the way that other companies have done this in cases that have come before you, the cases that have come before the district courts in Massachusetts, I've not been able to identify any other case that has just relied on the words terms of use. Almost all of them use some version of contract or agreement as part of the link, and I think that's significant. This court in Cowders made this point, I think, quite well. Reasonable users don't necessarily associate the phrase terms of use or terms of condition with extensive contractual obligations that would require someone to sign their life away. Lyft doesn't do that. They put the agreement. And in fact, if you were to go to the record in this case, RA 80, and you were to look at the first page of Uber's contract, no user is required to look at this. They don't put it in front of the user. But if you go, what you'll see On the first page, right at the top, it says contractual relationship. Further down on the first page, it says, please read these terms carefully because you are entering into a legal agreement with us. But none of that is put in front of the user on the interface pop-up that they are receiving and are being asked to assent to. It's not an accident. Uber is a sophisticated company. They obviously read this court's decision in Counters
But we don't have, I can't, there's some term on the internet about these, we don't have sort of dark practices here. We may have clever, but we don't have one of those where you're clicking one box and it's actually doing the opposite. There's some, I can't remember, there's a term in the internet contracting world where people do that. We don't have that. We just have sort of, less than obvious. They don't use the word agreement. They don't use the word agree, except for in sort of a subtler way. But we haven't quite gone that far. And Archer is, I was just looking at the language in Archer. By providing your electronic signature and clicking e-sign, you are acknowledging that you have read, understood, and agree to be bound by the terms of any content or document provided herewith. That's clear enough, right?
Right, and I'm not quite sure where you're reading from, but if you read one sentence below that, I think what you'll find is that the court identifies, and it goes on and says, in addition,
They were specifically informed they were signing an
they're
arbitration.
signing, exactly, Justice Kafka. And Uber could easily have done that here. And I think you asked this question to Uber before, and I see I'm out of time, if I could just...
But I'm worried, we're not just dealing with Uber, we're dealing with a world of internet contracts now, and how explicit they need to be for all different kinds of things. Is it because Uber is involved in a dangerous, business and it needs to be more explicit? I'm just trying to get a sense of how we do all of this.
So, no, I think the same standard applies regardless of whether it's Uber or, the social law library, which, one of the amici on Uber's side pointed out and said, oh, well, look at all of the ways in which designers are going to have to change their websites. If I could just, 30 seconds to respond. This is not going to require any kind of sea change in the way that companies do business. As we've pointed out, virtually all other companies follow what this court identified in Counters as essentially the best practices, at least in some way. Grubhub and Archer put the term contract in part of the link and made people click it. Lyft puts the terms in front of the user. Why doesn't Uber do that? It's not at all clear, but even if you were to look at the social law library website, which helpfully the defendants amici put on page 19 of its brief, the social law library puts the terms and conditions in front of the user before asking that user to assent to them. And I think what we're asking for here is just, I think, a fairly straightforward application of Counters that doesn't and wouldn't require companies at all to change the way that they design their websites or do business, unless the court has further questions.